Morning children. So in our previous chapter, we have covered the salient features of constitution, under part 1. So here, in the previous chapter, like we have covered in the constitutional features such as fundamental rights and fundamental duties. So they were all placed under, like for our categorization, they have named them as salient features of constitution, under one heading and as one chapter. And now we have covered fundamental rights and fundamental duties. So in this chapter, we are going to read about the directive principles. Okay, the other important feature of our constitution is directive principles of state policy. So let us study what are these directive principles and other details in this chapter. See, in the first chapter, that the making of our constitution, so we have even understood that while our constitutional makers, when they were making our constitution, they have adapted, or they have gone through the constitutions of various countries, and they have adapted the best practices of all the constitutions. So in the same manner, these directive principles of state policy, so they were taken from the Irish Constitution. So we know that the fundamental rights have been taken from American Constitution. So in the same way, these directive principles were taken from the Irish Constitution. So what are these directive principles of state policy? See, let us understand this term, directive principles of state policy. See, directive, the word itself suggests that somebody has to direct. That means somebody has to implement. And what they have to implement or direct? The principles of state policy. So we have even state policies, like the governments will make policies. That means some decisions for the progress of the nation or for the welfare of the people. So all such decisions are called as policies. And in making such policies, the governments should follow certain principles. So what are principles here? They are no fundamental truths. Okay. So basically, the directive principles of state policy they are the governments in while making the decisions regarding people, they have to take into consideration certain principles. So that all principles were grouped under this directive principles of state policy, and they have been taken from Irish Constitution or the Constitution of Ireland. And because in Ireland there was a national movement, and these principles were given by the the leaders of those country to their constitution, and later we have even adapted those principles to our constitution. And so in our constitution, while adapting these directive principles, we have not entirely taken Irish principles. We have also added some of our own national leaders' ideologies and other things also. Like if you take directive principles of our constitution, they include the principles of Irish constitution. Also we have the Gandhian principles. So that means Gandhi's philosophy, there are certain great ideas promoted by our national leaders. All such things were also included. And economic welfare, the foreign policy, legal and administrative way. So everywhere we have adapted certain principles so that in the governance of the country, they will help the people to progress. So these directive principles of state policy are very important in the progress of the nation. So this is about the history of directive principles of state policy. So let us have a glance or a glimpse at the kind of directive principles which India have. Okay, so the directive principles of our constitution are generally classified into socialistic principles, Gandhian principles and liberal principles. Okay, so I'll discuss these all words and terminologies in the later part of the chapter. So this is just to give you an overview of the what are directive principles, how they appear. So generally these directive principles are no, they are covered from Articles 36 to 51, and no, they are categorized into socialistic principles, Gandhian principles and liberal principles. So we have studied in the previous slide also that no, Indian directive principles of state policy does not only include the Irish principles, but also we include certain ideologies of our father of nation Mahatma Gandhi, and certain other aspects also we have taken. So these are all things were placed in article from article 36 to 51. So let us study those things, and now let us see the other aspects of the directive principles of state policy. So let us start understanding of the directive principles by knowing its meaning. So we have discussed the wordings of a directive principle. That means directive. What do I mean by directive? What are principles? I said that, like, they are the fundamental truths. And state policy, here state refers to the governments at state and central level. Policy means the decisions taken by governments. So directive principles of state policy, what is its meaning? The directive principles are the guidelines to be followed by the government in the governance of the country. See, here if you look at a family, there will be certain guidelines, where the father and mother will be creating us, so that accordingly we will behave. And from the family level, you take any other organization, even you take your schools, they are run based on certain guidelines, isn't it? So in the similar manner, the country's governance is also run by certain guidelines, and these guidelines are provided in the form of directive principles to the governments. Who will provide these guidelines? The Constitution of India will provide these guidelines. So where it is provided in the part 4 of the Constitution, these directive principles of state policy are included. So I repeat, directive principles of state policy. That means these are the principles or guidelines that the government should follow in making their decisions. So why do the governments make decisions? For the welfare of the people. So in looking after the people of the country, the government will take many decisions. In taking such decisions, they have to follow certain guidelines, and they are nothing but directive principles. They are placed in part 4 of the Indian Constitution, and from articles 36 to 51, all these directive principles are included. So you can even see what are these parts, like part 1, part 2. So in part 3 we have studied in last chapter the fundamental rights, and we have also studied fundamental duties are included in 4a. So in the similar way, part 4 was included with directive principles, and these directive principles are not substitute for laws of the country. So the governments also will make laws, right, for the governance of the country. So you may get a doubt that are these laws and directive principles are similar? No. In a way, the laws are also, when the governments make laws for people, they take inspiration from these guidelines. Okay, so you cannot completely take away laws and keep these directive principles, because directive principles are just guidelines. We cannot we cannot just keep them in a technical form. Hence they are just guidelines backing up all the decisions of the governments. In making a law, they'll have the governments can refer the directive principles, and they can get motivated from the principles, and through which the law will come in a more efficient manner. So they are not substitute for the laws of the country, but they help in the law making process and for the lawmakers to inspire. They are called directive principles because the government has to take them into consideration while making laws, as we have discussed. See, in making laws, what is the purpose? To run the governance of the country more efficiently. So to make such laws, the government needs certain principles, and that principles are provided by these directive principles of state policy. So the governments, while making laws, they must and should consider these directive principles. So it will help them to make very efficient and better laws for the governance of the country. And these principles contains ideas, deep human thoughts, beliefs and knowledge. So like many people's like you take Irish principles, like socialistic economic principles, many ideas will be there by great people, deep human thoughts, like how to bring the progress of the people, how to make people better in their standard of living. They all come under deep human thoughts, beliefs and knowledge. So all such things will be included in these directive principles, so that in making a law, a human angle, knowledge as well as beliefs, everything will be taken into consideration by lawmakers, and they'll make that laws, or they'll create such kind of governance. And these principles are not found in any other constitution of the world except those of India and Ireland. So in most parts of the world, these directive principles were not incorporated in their constitutions except in Ireland and India's constitution. So after understanding the meaning of directive principles, let us now try to understand what are the sources of directive principles. So we said that our constitutional makers, while adapting these directive principles, they have referred various sources for information. So what are those sources? What was the reason behind adapting this? Let us study that now. So at the time of drafting of the constitution, the framers were inspired by 5 important sources. So the framers of Indian constitution, that means who are involved in the process of making of constitution, they were inspired by 5 important sources. So when they wanted to incorporate things called directive principles, they were inspired by 5 important sources. What are those 5 sources of information that they got inspired? First one is the Constitution of the Irish Republic, which contains the principles of social policy of guidance. See, in the Irish Constitution, the legislators or the constitutional makers of Irish Constitution have incorporated certain principles called socialistic principles or principles of social policy. So in the Irish Constitution, there are certain principles for social policy. So what is social policy here? To run the society or to run the nation, some principles are required, and so that using that principles, the legislators, that means who make laws, they will make the laws based on these principles. So principles of social policy were present in the Irish Constitution, where the lawmakers of Ireland will use that principles in lawmaking process. So this was the first source, because of which our constitutional makers also felt such principles should also be there with us for our lawmakers, so that they can make better laws. The second one was the Declaration of Rights of Man and Citizens of Revolutionary France. So here you might be aware of French Revolution in your previous classes, where they have declared how they have fought against the the aristocrats and the kings, and how they came up with the rights of mans and citizens. So that Declaration of Rights, which is the output of French Revolution, was also taken as a inspiration by our constitutional makers. And the third source of inspiration was the ideas of Mahatma Gandhi. So once we just, if you think of Mahatma Gandhi and his principles and ideology, roughly you can say non-violence, speaking truth, many such things will come in the form of Mahatma Gandhi's ideology. So our constitutional makers also got inspired from the principles of Mahatma Gandhi, and they had lot of influence on the his ideologies, and they took certain ideologies from his they took certain principles from his ideology and incorporated in our directive principles. And the next fourth one was the Charter of Human Rights by United Nations. So United Nations, which is the common body for all the countries in the world, a common platform. You know that, at least you might have heard about it. So they have given some rights to citizens of the world. So that was also an inspiration for our. See, I'm not talking about citizens of this country. UNO has given certain rights for human beings. So before we are citizens, we are human beings, right? There are certain basic human rights. So that was also served as an inspiration for our constitutional makers to incorporate them into our principles. Some human rights were also taken as source of information. The Universal Declaration of Human Rights adopted by United Nations, so which is similar to that. And when the constitution makers were making discussions on these directive principles and other things, at the same time the United Nations accepted certain human rights, and it has commonly given to every human being on this planet. So the constitutional makers got inspired from such rights, and they have also included them in our directive principles. So altogether these sources of directive principles are 5, and they are from Irish Republic, from the French Revolution, and from Mahatma Gandhi's ideology, and from the United Nations proclamation of human rights. So these are served as an important source of directive principles for our constitutional makers. So now let us start understanding the importance of directive principles. So why do we require them? What is their importance? So before understanding the importance of directive principles, we should also study certain limitations are there in these directive principles. So what are those limitations? So like in the case of fundamental rights, there is a difference of opinion regarding the directive principles. So if you compare fundamental rights and directive principles, okay, so here the directive principles will occupy a major importance than fundamental rights, but there is also some significant fundamental differences between both. So what is the first difference, or what is the fundamental difference between the rights and directive principles? The fundamental rights are justiciable. That means if they are violated or if they are not enforced, anybody can go to court, and through court they can get their rights served. Whereas the directive principles are non-justiciable. That means if the governments do not take the directive principles into consideration in running the governance of country, we cannot go to courts and make them implemented, because they all deal with the moral aspects. So that we'll discuss in detail later why they are not justiciable and all. But basically directive principles are non-justiciable in nature. You cannot go to court and ask for the government to follow these guidelines strictly and perfectly so that they can be useful. So there are some reasons. This is a limitation to directive principle. And whereas if it is in the case of fundamental rights, if they are not enforced by governments, you can immediately go and through the form of writs and other ways they'll be implemented. So these are the limitations of the implementation of directive principles. Once you understand what are the limitations, then you can understand how directive principles are very important. So let us see how important these directive principles are. So the importance of directive principles. So the directive principles are in the nature of a pledge made by our constitutional makers to provide political and social and economic program for the modern democratic state. See, during the time of framing of our constitution, our nation was very much underdeveloped. So the people of the nation were not developed. So they need certain kind of progress. Some basic requirements were not there during those days. So to make the governments realize that the people's development is the highest priority, these directive principles served as a pledge. See, we even take pledge of our nation, right? Even today we take, no, India is my country and all such pledge. Why do we take such pledge? Because we strictly take ourselves that we abide by the constitution and we will work for such things. So even these directive principles served as a pledge for the constitutional makers, so that politically, socially and economically this country should progress. So the directive principles will resemble like pledge, saying that being the legislators of the country, which are nothing but the governments, they will develop this country politically, socially, which means, in society, all people equally having every opportunity and in every ways equality and other things. And politically, everybody should have a good knowledge and they should come up and they can decide the governments and all. Economically, that means financially. So this is a pledge which is for the legislators, so that they develop this nation politically, economically and socially to a modern democratic state. See, we have, that the country is running on the basis of democracy. That means, decision of majority people. So the modern democratic state can be created with political, social and economic development. And these principles of directive, or these directive principles, will serve as a pledge for reaching that kind of goals or such kind of modern democratic state. So that is one importance of directive principles. And these directive principles give guidelines to government to make laws and draft their policies. So in making laws or policies, okay, the governments will, they no need to, think on their, they don't need to just rely on somebody. If they just go through the directive principles, they'll get all the, motivational factor, as well as in what areas, how they have to make laws. All such things will be clearly, they can get an idea through this directive principles. And see, the purpose of constitution for our country, everything is also summarized in the preamble, right? Like, we the people of India solemnly resolve the sovereignty, socialistic republic. This also, right? So we have certain objectives for our constitution, and even such objectives of our constitution can be served through these directive principles. So the governments, in implementing the constitutional provisions for the country, they can take these principles as, guidelines, so that the objectives of constitution is served, as well as the government's duty of governing the country also becomes more efficient. So they also provide an element of permanence in democracy. So when these principles are not taken as guidelines, they can give a very stabilized, democratic nation. So not that instability and all. They help in the stability of the country, so that the country can progress well. The people of the country can progress well. And they also help the government's performance to be measured. So the directive principles are fundamental truths, I said. They are no fundamental truth, or fundamental in nature. And once you compare something which is very standard, then when the guidelines are used by government and when they work, you can see how far these governments have reached the fundamental targets in principles. So these fundamental principles or directive principles, they can help in measuring the performance of the governments. So this is also very helpful in the country's progress, as well as measuring the performance of government. Continuing with the importance of directive principles. So here the directive principles will direct the governments to move towards the goal of a welfare state. See, we have been saying that these directive principles are guidelines and like that. So what do you mean by guidelines exactly here? If you want to summarize all these guidelines, then the directive principles will ask the governments or will motivate the governments to move towards the goal of a welfare state. So here is a new term called welfare state you should understand. So what is welfare state? So it is a country or state where all the government policies and programs will work for the you know the basic meeting the basic needs of the people. Okay, so people will have certain basic needs like household, like food, safe environment and many such things. So these directive principles will enable the governments for working towards a welfare state. That means a state where or a nation where the basic requirements of people are covered equally. So the basic during the making of our constitution, as I said, the people of our nation were living in poverty. They were having many problems. So basic fundamental needs to be provided, and the governments in making their laws or programs, they have to design them in such a way that they meet the basic requirements of the people and create welfare of the people. And these principles also reflect the ideas of justice, liberty, equality, and fraternity, mentioned in the preamble. See, when justice equally given to everybody, it is also part of the welfare. If freedom is given to everyone, it is also part of the welfare of a citizen. Equality, which is again the same thing. Fraternity, now which is brotherhood, which is required for welfare of a person. So if every person gets welfare activities from government in such a manner, in their freedom, in their equality and other areas, definitely these principles will create a welfare state, that means a welfare nation. And these principles also enlighten and educate the people of what they can expect from the politicians whom they vote to power. See, these are guidelines we have studied till now, that they are guidelines to the politicians or legislators who are in the government. Also, these principles also make people aware that what things they require from the government. See, if they know what they require, then they can vote for that kind of governments. If they require a welfare oriented government, definitely these directive principles will make the people aware of those kind of welfare principles in the directive principles. So once these directive principles also make awareness among people about what kind of governments they require, and so that they can vote for that kind of governments. And they also provide a direction to courts in respect of safeguarding the rights of citizens. So rights are basic human thing. So the courts in the implementation of rights, they can also get inspired, or they can also get the way how to implement these rights. So whenever, see, courts, generally the constitution has given the rights, but whenever such rights are violated, then courts will come for safeguarding those rights. How to safeguard these rights from the political or the government wing, the courts will also get an idea. Okay, so from these principles, this kind of liberty, equality is there, and through this method I can safeguard the rights. The courts also get an idea of safeguarding the rights of citizens through directive principles. And these directive principles has definitely the public backup. That means definitely these principles look in such a way that all the citizens of the nation will be supporting them. And when such public support is there for these principles, then clearly it is revealed that the goal is social and economic order. The governments also will get a clear idea that these principles which are incorporated in the constitution is having public support, because of which only the framers have incorporated them in Constitution. When even people support such principles, the governments will not have any other option. They will take them into consideration and make better laws and legislations for the welfare of people. And the 42nd Amendment Act of 1976 is a law made to give effect to any of the directive principles. That see this 42nd Amendment Act of 1976 is a very peculiar amendment. So where if a law is made to give effect to any of the directive principles, it will not be declared unconstitutional even if it takes away any of the rights under Articles 14, 19 and 31. So what do you mean by this? Suppose if any law is made by the legislatures so that they may affect the implementation of directive principles. In such cases, they will not be considered as unconstitutional. If directive principles are having an effect because of the laws made by the legislators, then they will not be considered as unconstitutional, even if it takes away any of the rights under Articles 14, 19 and 31. That means these principles are more important than individual rights, because these principles will create a common welfare, whereas rights will give individual things for a person. So rights for an individual, not for groups, whereas these principles are for a group, for welfare. Hence here, to give any effect of directive principles, they can be even made some changes with the rights. So I'll repeat this last point once again here. So which is the 42nd Amendment Act 1976. So this is an act brought a change in the Constitution. So where it has suggested like this: if the legislator make any laws, okay, and if that laws are enhancing the directive principles, that means if they help the governments to implement these directive principles in more efficient way, then it will not be declared as unconstitutional, even if it takes away certain rights under 14, 19 and 31 articles. Putting it very simple, if a law is made to implement a directive principle, then what happens in some situations, some rights also will be affected. But even though some individual rights are affected, here these laws cannot be declared unconstitutional. If a law is made in such a way that rights are affected but directive principles will be affected, it will be implemented effectively, in such situations the law is not declared as unconstitutional. So you may get doubt that, sir, if rights are getting affected, then it is unconstitutional. No. Under Articles 14, 19 and 31, if those rights are affected also, if that law is helping the directive principles to get more effectively implemented, then they will not be declared as unconstitutional by any court. So what are these Articles 14, 19 and 31? They are like basic fundamental rights. 14 talks about the equality before law and equal protection of law, and Article 19 gives us the freedom, the sixth freedom, freedom of speech, expression, and all these things. And Article 31, where the right to property and all. Later, the right to property was removed, but there are other such things in these articles. So here, if a law is made and that law is affecting these three articles, 14, 19 and 31, but that law is helping directive principles to be implemented more effectively, then that law will not be declared as unconstitutional, even though that law is affecting the fundamental rights under 14, 19 and 31. That law cannot be declared as unconstitutional because they are promoting in the effective implementation of directive principles. So such is the importance of directive principles. So this 42nd Amendment in 1976 is very important, and this provision called, not declaring any laws unconstitutional even though they are affecting certain rights, is a very important provision in the Constitution for the implementation of directive principles. So because of such provision called, no law can be declared as unconstitutional even though they affect fundamental rights, if unless directive principles are implemented efficiently. So it's a very important place given in the Constitution for directive principles. So the governments can also take advantage of this, and they can work more efficiently for the implementation of directive principles. And if any conflict arises between fundamental rights and directive principles, then the directive principles will prevail. Because, so let us see why. Okay, suppose if anybody, if there is any issue based on no, the directive principles are non-justiciable, nobody can go to court, but still fundamental rights are affected, no, I can move to court. If such kind of dilemma, or if such kind of conflict arises, then everybody has to take the directive principles as the primary concern. So in case of conflict, directive principles will prevail more than the individual rights called fundamental rights. So why? Because the directive principles will promote the welfare of the people as a whole. So the directive principles always speak about the welfare of the whole nation, the welfare of the whole country or the whole citizens, whereas the fundamental rights only speak about individual rights. So when you compare, individually rights are more important, or the whole nation's progress, or the whole nation's welfare is important, definitely one will choose for the nation's welfare, or the welfare of the people as a whole is more important than their individual welfare or individual rights. However, the directive principles are not enforceable by any court of law in the country. So no court or no other judicial organization can enforce these directive principles like fundamental rights. The fundamental rights have that safeguards in through courts, whereas directive principles does not have that. But if conflict arises, they have to choose directive principles, because on moral grounds, both governments and courts have to always should be aware of these principles. So in any situation, if some rights are getting affected, but it is getting welfare for a large number of people, then the courts and governments will definitely opt for the common welfare and the large welfare of the people. So nobody can go and quote saying that we need these directive principles to be implemented, because it is a very elaborate thing. The morals and all, you cannot justify them in in writing, or by just keeping them. You cannot compile all the moral things. Okay, so instead they have to be taken into consideration whenever conflict arises. So this is about the importance of the directive principles. So let us look at the comparison of fundamental rights and directive principles here. The meaning itself says that the fundamental rights are rights of all citizens in the country. They are individually belonging to everybody, whereas directive principles, like, they'll just act as guidelines for governments to frame policies for the whole nation or for all the citizens. Rights are for individual citizens, whereas the principles are guidelines for governments for all the nation or for all the citizens. And these are present in part 3. The fundamental rights are present in part 3, and the directive principles are present in part 4 of the Constitution. So the fundamental rights, they are enforceable legally through courts, whereas the directive principles are not legally enforceable by courts. We have discussed, because these principles are moral in nature. you cannot define and keep these morals and ethics and all these things in a particular format. There is no limitation for defining all these things. Hence, they are not legally enforceable. But when consideration have to be taken, principles will be taken into consideration than rights. And these fundamental rights will give political democracy. Politically, they give some rights to people. Having certain rights is a political aspect, and this principles will give social and economic democracy. So in the society, as well as the economical matters of people, they give democracy in such way. Also, to implement fundamental rights, no legislation is required. They are rights directly enforced through constitution. No need for the legislature again to make laws for implementing these fundamental rights. There is no such necessity. Whereas directive principles, if they are to be implemented, laws are to be made compulsorily. Otherwise, you cannot expect them to operate. So this is the basic structural difference between the fundamental rights and directive principles.